Hearsay and impeachment. Okay, we're going to start with two threshold inquiries. One is the definition of hearsay. Hearsay is a statement made by the declarant outside of the current trial or hearing and offered to prove the truth of the matter asserted. Hearsay is, that's right, inadmissible unless it is offered for a non-hearsay purpose or qualifies for an exception. Hearsay is inadmissible unless offered for what? That's right, a non-hearsay purpose or qualifies for an exception. Our second threshold inquiry is, are we in a criminal case? Because in a criminal case, the defendant has an absolute right to cross-examine the witnesses against him under the Sixth Amendment. If we are in a criminal case, watch out for unavailable witnesses. The Sixth Amendment will give the defendant in a criminal case an absolute right to cross-examine the witnesses against him. And remember, testimonial evidence is inadmissible. Non-testimonial evidence will be admissible. Those are our two threshold inquiries. One, is it offered for a non-hearsay purpose? Does it fall under an exception? Two, watch out. Is this a criminal defendant? Then they have an absolute right to confront the witnesses against them. That is going to trigger the Sixth Amendment. And you must then analyze whether the statement is testimonial or not. Okay, hearsay is inadmissible unless offered for a non-hearsay purpose. We are going to divide this into part one and part two. Part one, we don't need the declarant to be subject to cross on the stand. And those are statements: one, effect on the listener; two, notice or knowledge; three, habit; four, refresh recollection; and five, opposing party statements. Effect on the listener. Watch out. Did this statement actually have an effect on the listener? Did it actually cause them to do something? Statements offered for notice or knowledge. Your brakes have been repaired. Do they have knowledge of some fact? Habit. Remember, habit is broadly defined, but in general, it must be some sort of reflexive conduct. Refresh recollection. We know how that works. Witness once knew, now can't remember well enough to testify accurately. Now we're going to offer them any object, allow them to examine it, withdraw it, and then the witness testifies to their refreshed recollection. And of course, it cannot be offered into evidence unless it is by the opposing side. Okay, so our first four are: watch out for the effect on the listener. Does it actually have an effect on the listener? Two, statements offered for notice or knowledge. Three, habit, broadly construed. Four, refresh recollection. Now five, opposing party statements. Watch out. Examine whether this is offered by the opposing party against them. And this includes, of course, the opposing party's agents, employees, and co-conspirators. An opposing party statement includes what? Their agents, their employees, and their co-conspirators. And it also includes their admissions, including their adoptive admissions. So that is part one. One, effect on the listener. Two, notice or knowledge. Three, habit. Four, refresh recollection. Five, opposing party statements, including agents, employees, admissions, and adoptive admissions. Part two, the witness must be in court testifying and subject to cross. Part two, non-hearsay, but the witness must be in court, subject to cross. Statements of prior identification and prior inconsistent statements made under oath. Okay, statements of prior ID. The witness must be in court subject to cross. If so, a statement of prior identification is not hearsay. A prior inconsistent statement, we know the rule. If it's offered not under oath, it can come into impeach. If it is offered under oath, then it can come in for its truth. But in either case, if the witness is not there, they do not have an opportunity to what? Explain or deny. For a prior inconsistent statement, if our witness is on the stand, they must be able to, if they're in court, they must be able to explain or deny. They can't flee the jurisdiction. Okay, so those are our non-hearsay purposes. Effect on the listener. Notice or knowledge. 3, habit. 4, refresh recollection. 5, opposing party statements. And then we've got to have the witness on the stand to prove prior identification or prior inconsistent statements so the witness can explain or deny. Okay, next up. We don't care whether the declarant is available or not. These are the exceptions. Exceptions, we know them. Present sense impression, excited utterance, state of mind or present mental, emotional, or physical condition, including intent to travel, medical diagnosis or treatment, recorded recollection, business record or absence, and public record. Okay, 1, we don't care if the declarant is there or not. If it is their present sense impression, describes or explains an event while or immediately after the declarant perceived it. 2, excited utterance, a spontaneous admission, a spontaneous statement made in response to a startling event while the declarant was still under the stress of the excitement it caused. A statement regarding their present mental, emotional, or physical condition, and that includes, of course, intent. A statement for medical diagnosis or treatment made for and reasonably pertinent to medical diagnosis or treatment. Our recorded recollection. Remember, witness once knew, now can't remember well enough to testify fully and accurately. We're going to read that into evidence, and it is then admissible for what? That's right, it's truth. Business record or absence of a business record made during the course of the office's activities. It's a regular practice of that office to make such reports, and it is shown by a person with knowledge or the custodian. So for business record or absence, we need a witness with knowledge. The record's made in the course of the business. It's the regular practice of the business to keep such records. And we have to show it by the testimony of the custodian or a witness with knowledge. Public record, remember, no police reports in a criminal case. Made during the course of the office's activities by a person with a legal duty to report, and shown by the testimony of who? The custodian or another qualified witness. And of course, for a business record or public record, certified copies are okay. Okay, so we have our non-hearsay purpose. Don't care if they're there. Effect on the listener. 2, notice or knowledge. 3, habit. 4, refresh recollection. 5, opposing party statements, including agents, employees, co-conspirators, and admissions. Non-hearsay statements. Witness must be there, subject to cross. 4, statements of prior identification and prior inconsistent statements, so that witness can do what? Explain or deny. Now we have our exceptions. Present sense impression. 2, excited utterance. 3, present mental, emotional, or physical condition. 4, medical diagnosis or treatment. 5, recorded recollection. 6, business record or absence. 7, public record or absence. Okay, and then we have our 3 witness unavailable exceptions. The witness is unavailable. 1, watch out for the confrontation clause. Watch out. If they're unavailable, watch out for the confrontation clause. Is it testimonial? Then it's out. Okay, but let's say we're not dealing with a defendant, criminal defendant. Dying declaration. Remember, that's only what? Homicide or civil. Dying declaration is only homicide or civil. Assault, that's not a dying declaration. They didn't die. And, well, they don't have to die. Dying declaration, only homicide or civil. If it's criminal and it's assault or some other crime, it is not going to come in. Statements against interest, penal or financial. And 3, former testimony under oath where there was what? That's right, a similar motive and opportunity to cross. So our 3 unavailability exceptions. Former testimony under oath, there must be a what? Similar motive and opportunity to cross. Statements against interest. Dying declaration only, homicide or civil. Okay, finally, impeachment. Why does this go with hearsay? Because we are using hearsay a lot of times to impeach witnesses. For impeachment, watch out. Who is the witness? If the witness is a criminal defendant, we're going to watch out for what? Testimonial evidence that might implicate the confrontation clause. Our rule is any party may impeach a witness, including the party that called that witness. Okay, how are we going to impeach them? Number 1, their character for truthfulness, their credibility. We can impeach them with their prior inconsistent statements or rehabilitate them with their prior consistent statements. We can impeach them with their other bad acts, not a crime, lying about your job application, lying about your college transcript. That's an other bad act. Other bad act. Watch for it. Criminal convictions, what do they have to be? A felony less than 10 years old, or that's right, crimen falsi. What if they're more than 10 years old? The probative value must substantially outweigh prejudice to that defendant. And of course, we can always impeach on bias, interest, motivation, and sensory deficiencies. Okay, any party can impeach a witness. What's our number 1 way? Character for truthfulness. Second, prior inconsistent statements or prior consistent statements to rehabilitate. I've seen other bad acts all the time. We cannot prove those with extrinsic evidence. You lied on your job application. Didn't you lie? No. Okay, now we want to offer your job application into evidence. No, that is extrinsic evidence. You can't prove it with extrinsic evidence. That has tripped you up. Criminal convictions. Are they less than 10 years old? Okay, probably they will be admitted. If it's crimen falsi, must be admitted. If it's more than 10 years old, only if probative value outweighs prejudice. And of course, you have to give notice. And finally, do not forget 1, bias, 2, interest, 3, motivation, and 4, sensory deficiencies.